Okay, so we're going to go ahead and get started. Good afternoon. My name is Alicia Magana. I'm the CEO of KIMA Events. Thank you so much for joining today's webinar on California AB5 and the event industry. I decided to do this webinar in January because a lot of my fellow event planner colleagues had a lot of questions about AB5, as did I, or they didn't even know about AB5, which became effective as of January 1st. And I had attended a few general AB5 workshops. I did my own research. I spoke to an HR administrator, and I also spoke to a few attorneys. But I wanted to know how this was going to affect my business specifically and other event businesses. And I know that there's exemptions, so can be very industry or occupation specific. And I know that other companies wanted that information as well. So this webinar is going to be an hour and a half. And we have two guest speakers. We have Jennifer Grady from the Grady Firm, speaking from an attorney perspective. And then we also have Ricky Johnson from RTJ CPA, and he's going to be speaking from an accountant perspective. So we're going to start going over the California AB5 law and all the nuances of it. So even if you've attended a webinar on this topic before, we will try to make this topic as easy as possible to understand. And we'll go into greater detail, including practical examples, so that you can get a solid understanding of how this new law impacts you and the steps you need to take to become compliant. And then we're going to look at some event industry specific scenarios and how they measure up on the ABC test, which we'll explain shortly, to determine if someone is an independent contractor or an employee. Today's webinar will be led by Jennifer Grady of the Grady Law Firm, who will introduce herself in a few moments, and she'll provide next steps at the end. So at the end, we know how to move forward. As a disclaimer, I do want to mention that the information we cover on this webinar does not take the place of speaking to an attorney, so that they can understand the nuances of your business and provide counsel based on your unique situation. And lastly, we'll open it up for Q&A. We'll do some questions with Jennifer. And then if you have additional questions, you can email Jennifer directly. And the law may change in the next few days, in the next few weeks, in the next few months. And Jennifer will address that as well. And then after that, we'll have Ricky Johnson from RTJ CPA, and he'll be able to share some insight as well, and then take a few questions as well. So now I'd like to welcome Jennifer Grady of the Grady Law Firm.
Hi everyone, I'm so excited to be here. I have hosted several webinars just on AB5 since January because it's such a fundamentally different change to the law, and it affects anyone who either works with independent contractors or is an independent contractor themselves. I'm an employment lawyer in California. We practice employment law, immigration, and business law, so we're really the outside counsel for expanding and growing businesses. We do on-site training, leadership, sexual harassment prevention training in English and Spanish, and we have offices in Beverly Hills, Newport Beach, and San Diego, California. So what we're going to do today is dispel some of the myths, talk about what AB5 is. We'll tell you why it matters. I know a lot of people have been procrastinating on making changes here, and you'll find out that if you haven't done anything yet, you're already a little bit behind. So we're going to teach you what is the ABC test, what are the exemptions, what is the Berello test, what to do if you've listened to the presentation and you said, you know what, I don't care, I still want to either myself or have my workers be independent contractors. We'll tell you what to do in that situation. We'll tell you how to convert independent contractors to employees. And then at the end, we'll talk about whether there is any hope for changes in the future, and of course, what to do next. So first of all, a little bit about AB5. It was signed into law last September by Governor Gavin Newsom, and it took effect this January 1st, 2020. So it is the current law of the land. So whether or not it changes in the future, it's already the law as of today. So we do have to proceed along those lines. And it's, again, as I mentioned, one of the most significant disruptions to California employment law in decades. And so why does this matter to you, the listener? You may say, you know what, I'm a small business, I'm just doing my own thing. why does this matter to me? And there's a few reasons why. So first would be increased audits by the Employment Development Department, and that is run by California, and also IRS audits. Keep in mind, both of these agencies want to receive payroll taxes, they want their taxes, and so they're going to be doing audits either on their own accord, or if someone makes a call and they get wind of it, then they might be running an audit. For example, if you've had maybe 300 independent contractors, you might be primed to be getting an audit. Second would be lawsuits and labor claims, and this can happen either if you have someone who left on a bad note, or maybe they weren't able to find a new job, and so they heard from their friend that they got money from filing a labor claim, or maybe there really was an error in how you process things, and so you may be getting a labor claim or a lawsuit. Keep in mind, those can be very expensive. They can be tens of thousands of dollars in attorney's fees to defend, plus penalties and interests and fines for these problems. So if anyone has ever been sued, they know their ears perk up and they know to listen to being compliant. Other things to keep in mind are that 1 out of 10 workers are independent contractors in California, and 80% of them want to maintain their flexibility. So while there are some arguments that the changes in law are helping people from being exploited, the other side of the coin is that we've evolved into this new landscape where people actually enjoy having the flexibility to go to auditions or have multiple jobs or take care of family members. And then getting down to the financial side, Gavin Newsom, the governor of California, has pledged $20 million to enforce AB5, and so that may come in terms of audits or various enforcement methods. And then number one is that penalties can range from $5,000 to $25,000 per violation. And that can also add on attorney's fees and interest and things like that. So that's just a starting point. So hopefully now we have your attention and we can talk a little bit more about the consequences. Just to add on to that, if you didn't pay the taxes that you were supposed to pay, which you would have paid in each payroll, those will be added on. You might get fines for employee benefit obligations that weren't met. Again, an employer would be paying workers' compensation, and so if you haven't been doing that, there could be fines there. There's unpaid overtime and minimum wage. So as you know, anything over 8 hours a day or at the 7th day or 40 hours in a week, you're going to be getting into overtime, which is time and a half. And then in certain circumstances, you can get double time. And so if there were should have been an employee and they weren't, you haven't been paying that overtime. And so then you would get fees, penalties, and interest for that. Waiting time penalties are when your final paycheck was not issued correctly. You can get about 30 days worth of salary as a penalty.
Technical difficulty, give me 1 second. Jennifer, are you there?
Yes.
Okay.
Okay, I've been talking. Where did you lose me?
You stopped at time and a half.
Okay, great, thanks. Okay, so as I mentioned, time and a half and up to double time for overtime if you haven't been paying that, and you should have. Then we also have waiting time penalties, attorney's fees penalties, and other penalties and interests that government agencies may tack on. So one thing to keep in mind as the thread throughout this presentation, if you remember nothing else from today, is that the presumption under California law is that workers are considered employees presumptively. So that means the law assumes anyone working for you is an employee. And if you're the employer, the burden is on you to prove that they should be an independent contractor. But a lot of people, I assume, on this call are the independent contractors themselves. And they may say, okay, well, if it's the employer's burden, why do I have to deal with it? And that is because you're in business perhaps for yourself and you want to work with these people. And they may say, well, I don't want to work with you. There's too much risk. So if you can legitimately be an independent contractor, you're going to want to update your agreements to make sure they're compliant with this law. So at the end of this presentation, no matter where you are on the business side, you will have to take action, and that's either updating your independent contractor agreement or making one if you don't have one so far, or converting people to employees, and we'll teach you how to do that. So first of all, the ABC test is the new change to the law. And the reason for this is that we'll be talking about the Berello test later, which was the prior test. And that test was a little bit challenging because it's looking at the sum of the parts rather than a specific, you must meet these 3 factors. And so that was a little bit challenging for employers because they never knew at the front end whether someone was an employee or not. And so that is why they created this test. And there's 3 elements that must be satisfied in order to avoid being an employee. So first would be that the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. So the number 1 word that we're going to be looking at here, whether someone is an employee or independent contractor, is control. So are you telling this person what to do, how to do the work, all of that? If so, then they are going to be an employee. The second element is that the person performs work that is outside the usual course of the hiring entity's business. And 3, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So let's take the example if you were to hire an attorney or a CPA. We can look at number 1, is the person free from control? Yes, you're not telling the specialist how to do their job, usually because they went to school, they're doing a niche, and you don't know how to do it. So you're going to ask them, please prepare my taxes. They're going to do it, and you're not going to tell them really how to do the job. Number 2, that job is outside your usual course of business. You may be an event planner, and clearly preparing taxes is not part of your business. And 3, they have their own independently established trade, occupation, or business of the same nature. So if they're an accountant, they're performing accounting functions. If they're a lawyer, they're performing attorney functions. So that's kind of the new test, and the purpose of it is to have certainty that either you meet these elements or you don't. But unfortunately, this analysis doesn't end there. This is really only the beginning. There are many carve-outs and exceptions that were made based on lobbying, based on various reasons, and so we're going to go ahead and explore all of the different exceptions to the rule. And so, Alicia, do you have any questions so far?
No questions so far. Does anyone have any questions?
So you can go ahead and type those in the chat bar, and we'll keep going. So first, what about the exemptions? So the new case is called Dynamics that authorized this new ABC test. And so we would be using that unless we have one of the exemptions. And then if we do, we would be applying the old test, which is the Berello test, and that's the last test that we'll be going over. So if you were to read the statute of AB5, it's a very long, it's very tiny font. You can read it many times and maybe even come up with a different answer, but this is really the crux of the issue. So the first type of occupations that are exempt, I call them ones with a California license. So that would be lawyers, architects, engineers, or accountants. Securities, broker dealers, or investment advisors. These are professions that people went to school for and had to take a licensed exam and register with the state of California. We also have private investigators and certain licensed healthcare professionals like physicians, surgeons, dentists, podiatrists, psychologists, or veterinarians. And remember, I said that it doesn't always make sense who was included in here, chiropractors or not, so they would have to see if they qualify under some other type of exemption. And then lastly, someone who is licensed by the Department of Insurance. So the next category that may be of more relevance to the people listening to the call today are for professional services, and that includes marketing, administrators of human resources. So sometimes people would engage a third-party HR company that would fall under this exemption. Travel agents, graphic designers, grant writers, fine artists, payment processing agents, photographers or journalists, and freelance writers, editors, or cartoonists. And so the thing important to know about the photographers, journalists, and writers is that they're only considered an independent contractor if they write 35 or fewer publications per year. So once they get to 36, they roll over into, not roll over, but they would have to be classified as an employee. And so a lot of people have taken challenge with that. For certain writers, they might do that in 1 week. So they are trying to organize and see if they can change that law. But for anyone, if you use someone who does marketing or graphic design, they can be exempt if they follow the following test. So Berello test would apply to them if they meet the following 6 requirements first. So number 1, the individual, and that can be a sole proprietor or a business entity, maintains a business location, which can be their residence, but that's separate from the hiring entity. So for example, if you're a marketing person, you may have a few clients, your address is going to be different from theirs. That's really what that means. And then a sole proprietor is somebody who chooses to go into business, and you would be separating your business accounts as well, but they have not registered with the California Secretary of State, for example, as a corporation or an LLC. And then in order to be what's called a DBA, you can be yourself doing business as Monroe Events, but you would have to register with the county and where you're doing business. You'd have to pay a fee. You'd have to post it in the newspaper for 4 weeks or so. In my opinion, if you're going to be in business for the long haul, it's worth becoming a legal entity, because otherwise you have no protection. So if someone is injured on your property or they sue you, they can go after your personal assets. It's about $100 or so, plus or minus, to register your entity. You have to do a few things and then pay at least $800 franchise tax board fee. But other than that, I think it is worth doing that. So you would want to speak with a lawyer about incorporating your business. Number 2, starting July 1st, the individual has a business license and any other required professional licenses. So say, for example, you're in Los Angeles, you would register with the City of Los Angeles to get a local business license. Usually those are much less expensive, although Beverly Hills has a big fee up front. So that might be something you want to consider where you are doing business if you haven't made that decision already. Number 3, they have the ability to set or negotiate their own rates for the services performed. And that is where you as the business owner would be telling the client how much you charge. And while you may negotiate that, it's different from them saying, we're offering this per hour, take it or leave it. Number 4, they can set their own hours outside of project completion dates and reasonable hours. So the client may say, I need you to be available between 8 and 5, but other than that, you're setting your own schedule and meeting their deliverables as they request. Number 5, they're customarily engaged in the same type of work performed under the contract with another hiring entity, or hold themselves out to potential customers. So here, what they're really getting at is if you have only one client and you're at their site every day, that's starting to look like an employee. But if you have multiple clients, you would want to have a website, you would want to have a Yelp or a Google page, be in other directories, and then have evidence of that. And then the last piece is customarily and regularly exercises discretion and independent judgment in the performance of the services. So that's where, if we're hiring, for example, a marketing person, we're not telling them how to do the job. We may be giving feedback, but ultimately, in terms of how to do the work, they're making the decisions there. So then the next one that may or not be relevant here would be the beauty industry. And the following licensed beauty professionals can get around the ABC test and use the Berello test instead if they're an esthetician, an electrologist, a manicurist, and for some reason theirs is only valid under this law until January of 2022, a barber, or a cosmetologist. So if you are working with these types of people in your event planning, that may be relevant to you as well. But they, in the beauty industry, have an additional set of tests that they can do this if they meet the following. They set their own rates, process their own payments, and are paid directly by clients. So what we're really distinguishing here is somebody who maybe rents a chair in a salon or has their own business versus someone who works at a salon, gets all their business through them, and has someone else do the scheduling and the payments. They set their own hours of work and have discretion to decide which clients they will take. They have their own book of business and schedule their own appointments. They maintain their own business license for their services offered. So again, as these types of people, you would need a license in California. And they have a location. And well, if they have a location, if the individual is performing services at the location of the hiring entity, the individual issues a 1099 to the salon or business owner from which they rent the business space. So again, you're renting a chair, you're doing a 1099. Okay, so we've gone through some of the major exemptions, but what if you or the people you work with don't qualify under those? We want to talk about whether there are any other options, and there is a few other potential options. And so the one that I find might be most relevant as a catch-all if you don't meet anything that we discussed before is the business service provider contracting relationship. And so in this case, that ABC test wouldn't apply, and we would use the Berello test if you are a business entity and not an individual worker. So remember, a business entity can have just one person, but in your contract, instead of instead of Jane Doe, you would have Monroe Events LLC as the client. And so the business provider exemption has many parts, and it's similar to what we've been talking about before. Remember, the point is to really show that these people have their own business, they have more than one client, they have their own location, they have a contract in writing. They advertise and hold themselves out to the public. They provide their own tools, vehicles, and equipment, negotiate their own rates, set their own hours and location, and this is not something that falls under the Contractor State Licensing Board. And so then the last piece is that there are a few other professions that are exempt under AB5, and if you were to look at the statute, it would be under subsection G, in which Berello would apply, and that's for construction contractors, subcontractors, construction trucking services, or a referral agency that connects clients with service providers that provide, for example, graphic and web design, photography, tutoring, event planning, minor home repair, moving, home cleaning, errands, furniture assembly, dog walking and grooming, picture hanging, and pool or yard cleaning. So if you have been listening so far and you find out that the relevant professions that are of interest to you are governed by Berello, then we would go through the prior tests, and then if you were able to say, yes, we fulfill all of those pieces, then we would move on to part 2, that is fulfilling the rules of the Berello test. And so this test, again, is similar to what we've been talking about, but it includes whether the person performing services is engaged in an occupation or business that's distinct from that of the principal. So maybe you're in a recruiting manner services, and that's something outside what that company does. Again, marketing is another example. Whether or not the work is part of the regular business of the principal or alleged employer. So this is one area where people might get stuck because what they're doing may be a part of that company's regular business. And so then your defense there would be that, okay, we didn't meet that one, but we met 10 out of the 12. And so the difference between Berello and ABC, the ABC, you would look at the test and know right away whether the people qualify as employee or independent contractor, but Berello is something that's actually going to be addressed after the fact. And so that would be if there were a lawsuit or a labor claim and somebody says, you misclassified me, I should have been an employee, then you would say, well, we meet the Berello test actually. It's more points in the favor of them being an independent contractor. Again, we're looking at who's supplying the tools, whether the person invested a lot in the business, and so that might be easier to show. For example, if they purchased their own commercial vehicle and fancy equipment, that's going to be a check on the independent contractor side. Whether the business requires a special skill. So if somebody is an administrative assistant, you may argue that doesn't require a special skill. So that might be a point in the employee box. And then whether this is performed typically by a specialist without supervision. And the person's opportunity for profit or loss. And so if you're an employee, you're working there every day, you don't have profit or loss, you're getting paid the same. Whereas if you're in business for yourself, how much money you make really depends on how much you're hustling or how good you are at business. The length of time for which the services are to be performed is also something they would look at. The degree of permanence, so if this is like something you're working for them all the time, every day, that might look more like an employee. How you're getting paid, whether there is the right to fire at will, or if you have a contract that says this is for a one-year term and can only be terminated for a material breach, that might be more independent contractor. And lastly, whether the parties believe they're creating an employer-employee relationship can be important, but that one can be overlooked by the government. So they may say, just because you say you agree, but the job is really showing something else. And the point of that is because sometimes people may be coerced into becoming an independent contractor when they really should be an employee. And so the point of this is just to prevent people from saying yes because they think that they should. So lastly, how did the Berello test and the ABC test compare? The ABC test requires that the employer meet all three elements of the test in order to be exempt from dynamics, meaning that they are employees. And so to be an independent contractor, you'd have to meet all three elements. And then under the Berello test, there's no one factor that determines if someone's an independent contractor. The court would look at all 12 pieces and then they'd be making that determination after the fact. So for all of those of you that are using the Berello test to say you have an independent contractor, you may not find out until it actually gets to the courts whether the judge is going to agree with you. So again, that's really why you need to speak with an attorney who knows this topic so that you can find out and feel confident before you proceed with this relationship. So you may be confused and saying, oh my gosh, there's so many pieces, which test, when do I apply what do I do? So the first thing I would recommend is to hire a qualified California licensed attorney to help you through the analysis. And that doesn't mean a divorce law attorney or necessarily even a business law attorney. They need to be employment and labor law attorney who has dealt with this. They've been researching it since last fall, and they know how to read the statute, what cases have been going on, and how to help you. The second piece is to decide whether to make the worker an independent contractor or an employee. You're going to have to make that decision in the next few weeks what you're going to do. And then you would have to update your contracts or employment documents accordingly. And so no matter what position you're in at the end of this call, you would have to take action either way. So if you don't have a contract, you would make one or make it compliant, or if you realize, you know what, I really need to make these people employees, then you would create the employment relationship and those documents. So if you decide either I believe or my attorney is confident, or there are people that say, you know what, even though you tell me they really should be an employee, I just can't afford it, I'm going to have them be an independent contractor and take the risk. So at the end of the day, that's really what it comes down to. And we talked about potential consequences early on in the conversation and told you what the penalties are. And so if you're saying that's okay, I just want to keep proceeding, then you would need to update your agreement and then keep documents to prove that. So remember, we had talked about the person having their own business license or LLC, having a contract. You would want evidence of all of that, and you would keep it in a file. Share that with your attorney so they have a second copy. That way, if any of this does come up later, you can say, all right, we had this agreement, they showed me that they're really in business for themselves, and we believe that they are legitimately an independent contractor. So if you decide, you know what, it is not worth the risk, and keep in mind, I don't want people to think it's so daunting that they have to be out there taking risks. If you think it's more likely than not that they should be an employee, just make them an employee. So what you'd have to do is convert them. So you would give them notice that they would be an employee. So you might give them a notice of status or an offer letter saying that you will be an employee starting on this particular date. You would onboard the employee and have them sign documents. And so to make it easy for everyone, we've created a kit where we have 20 documents from before the time of hire to during employment to termination. And so we've created a whole kit of documents that you can use and make it easy for yourself, and you don't have to wonder if you're having everything that you need. And so that would also include an employee handbook, which is your opportunity to have the rules and regulations for your business and also let people know of the leave laws that are required in California. And so that's a topic for another day. But if you are going to become an employer, you do need to look into what those are. For example, pregnancy leave or FMLA, that would be if you have 50 or more employees. But there are all types of things that you really should be educated on what they are. Then you would implement payroll and benefits. If you need a referral to a benefits provider, you can let me know. Otherwise, some big ones out there, ADP or Southland Data Processing, and they can help you with the payroll. I don't recommend trying to figure out the numbers by yourself. It's just not worth it, but ultimately you are responsible for making sure the payroll is done correctly. We can't say, oh, the payroll company didn't do it correctly, so I'm not responsible. So make sure that the wage statements are correct, make sure they are making the right deductions and providing cell phone reimbursement that's required for employees, and paid sick leave that is also required for employees. You would distribute W-2 forms and have that, give that to payroll and to your accountants, and then create personnel files and keep good records. So all the documents that we're keeping, we're going to have them in a safe place so that we make sure we have them later on when we need to produce the file. So now that we've thrown a lot of potential legal mumbo jumbo at you, what we want to do is discuss some event industry scenarios so that we can really take this home and have you understand what does this look like. And we may or may not cover something related to you, but you can kind of extrapolate what the issues are. And I recommend, again, speaking with an attorney about your specific situation, but this is an overview of where to go from here. So the first one we have is talking about someone who is a day of on-site registration manager.
Jennifer, really quick, it looks like we have quite a few questions that have come in, so we're going to get to those. We'll answer a few questions, and then if we have some time at the end, we'll answer some additional questions. And then also, you can email your questions directly to Jennifer, and then if you have any accountant-specific questions, you can email those directly to Ricky. I think so far from the questions that have come in, I think when we go through these scenarios, we're going through, I believe, 4 or 5 scenarios. I think it'll address many of the questions, but we'll go ahead and go through them and see if you still have questions after that. And for these scenarios, if you see LLC or Inc. or Corp. Or even sole proprietorship, so any type of business entity, that's what the LLC would would represent. So you can use that example for any other type of business entity as well.
Correct.
So for the first scenario we have our day of on-site registration manager. So I'm sure a lot of people on this call, they might hire people just for day of. I know sometimes I hire someone to help me with stage management. I just have them on site a few times a year helping me. So in this case, Power Events LLC, they hire Bob Smith to manage registration on April 20th, 2019 for their client's annual charity event. So the owner of Power Events, Carla, schedules a call with Bob, walks him through the event and the process of how she would like the registration to be managed. Bob helps other event companies with day of event support, and he has his own DBA. Power Events LLC hires Bob for on-site registration management for 3 one-day events in 2019. So is Bob an employee or an independent contractor? Jennifer.
Sure, and just to clarify where we said he has his own DBA, we meant LLC, which is limited liability company. So he has his own separate entity. And so really where this is going to come down to is do you have control over what he's doing? Does he have his own company? And is he kind of practicing in that area? So can you tell me a little bit more about what he is doing in this job?
So on the day of the event, he's managing registration. So at the table, there's 2 tables set up at the front of the event. As guests are arriving, say there's 300 guests, he's overseeing all the volunteers at the registration table. So there's, say, 6 volunteers that are checking people in. He's making sure that section of the event is running smoothly on the day of the event. And so Power Events hires him 3 times over the course of the year to do just that job. They don't need him year-round on planning the event. They're able to handle the scope of work and planning the event on their own, but they need to bring in extra support on the day of the event.
Okay, so he's a day of staff person, so he's not necessarily doing something maybe perhaps what his company might do on its own. So if we were to look at the ABC test and we were to say, is this person doing something outside the normal course of business? It sounds like no, what they are doing is exactly what Power Events does. So then we would have to look to see if this person would qualify under the business service provider exemption, and that would be to show that they have their own separate business, that it's all of the things that we talked about there. And if you cannot show that they meet that exemption, then we would say that they're an employee. So even if it is for only 3 days, and I'll talk about this again later, even if it's just for 1 day, they can still be an employee. So you can have them be a part-time employee. They would still accrue paid sick leave based on the number of hours that they work, but then they would be an employee in that scenario.
So now we have some outside event vendors. So Gratitude Weddings, Inc., they hire all their vendors for their clients. So they hire the DJ, the florist, event rentals, photographer, linens, all these vendors. They do this all year round. They provide services for weddings and events all year round. Would these vendors be considered independent contractors or employees?
So likely these people could get around the ABC or make the ABC test in the first place because you wouldn't have control. You're not telling a florist how to do their job. They have something that's independent of your business. So that would be my first thought. And then the second would be if you can't prove it under there, to do the business contractor exemption. And then in your contract with them, they would say, we have our own business license and all of the things that you would check off. So when I have been preparing new independent contractor agreements for my clients, for the ones that say either we all agree that they can be an independent contractor, or the client would say, it's going to just totally destroy my business model. I'm going to make them be an independent contractor, but what is the best thing that I can do in that scenario? So we would update the contract, and I have them actually check a box and write yes to make sure they have all those elements of their own independent business. I even have them put, you know, what city they have a license from and attach a copy of it with the contract so that you can do your best to protect yourself in that situation.
So now we have fundraising and marketing. So Hummingbird Events, Inc. is hired to organize a summit for ABC Company. ABC Company asked if Hummingbird can support them with marketing and fundraising as well, although these services are not advertised on Hummingbird's website as a service. Hummingbird brings in Bellona Marketing Corporation and Amethyst Fundraisers, LLC, to handle the marketing and fundraising portion of the contract. Would Bellona Marketing be considered an independent contractor or an employee?
So as we mentioned, marketing is one of the areas that would fall under the exemption. It was the second category. And so if you were able to show we met the 6 requirements, then you would move on to the Berello test. Again, showing that they are in independent business for themselves, and you would want to limit what they're doing to only marketing. So don't say, oh, they do marketing, but then also have them do this event planning, which is really a major part of your business. You would really narrow it to only those activities. And with Amethyst, I don't see fundraisers having its own carve out. So they would also try to show under the ABC or the business service providers exemption that they are in their own business doing something outside of your control and have their own business that's regular their own business.
So now we have a freelance event planner, and I saw someone ask that question, that they do event planning full time, but they also do some events on their own, freelancing. So Jenny Jones is a freelance event planner for Cabby Social Events, Inc. She's been helping other event companies as well for almost 10 years. She works year-round from home and makes her own schedule. She helps with various tasks for several events, such as venue selection, vendor procurement, talent management, and she does work at the direction of the hiring entity. So is Jenny an employee or independent contractor?
So the crux of this hypothetical would be the fact that she's doing things that are within the normal course of business, and it's at the direction and control of the hiring entity. So if she can't show that what she's doing under Cabby Social Events is going to fit all of the exemptions, then she may be an individual that's a part-time employee.
All right, just back to the one-day example. So Crystal Production Inc. has a conference coming up next week. Its stage manager gets sick, and so they ask a family friend, the owner asked a family friend with production experience who's no longer working, they're now retired, if he could save the day and come on site for one day and just run the show for $500. Is the friend an employee or independent contractor? And I specifically added 500 because I know with the previous independent contractor law, like you don't have to 1099 if it's over a certain amount, but I know that that's not the case for this new law, so it doesn't matter the amount.
And so in that case, the amount would be $600, and we can ask Ricky for further clarification on that. But the point of this was, even if it's one day, yes, you can be an employee for just one day. So if that were the situation, even if it's last minute, you would want to bring your employee kit with you. You can either email it to them the night before or bring it with you on the day of, and they'd be filling out that W-2. They would fill out an I-9 that has to be filled out within 3 days of hire, and you have to do it in person. You can't, because you have to look at their ID, either driver's license and social security or a passport. That's to show they have eligibility to work in the US. So if they weren't a citizen, they'd have to show you an employment authorization card showing that they have a visa or green card that allows them to work. And so there's a few things that they would fill out. You put them on payroll, and then you would just pay them for the amount of work that they do. And so if you are having a lot of people coming in and out of your business, speak with your workers' compensation carrier. I know you have to estimate up front what the costs will be, and then after the next year, you'd go back and figure out how many hours people actually worked. And then again, this person is not into business for themselves. They're just a friend. So that also would take them out of any of the exemptions as well. Okay, so those were kind of a few scenarios. You may be asking questions right now that we'll get to at the end, but the question is there any hope that the law will be changed? So the short answer is this is the law of the land now, so whether we like it or not, we have to comply with it as it's written. And so you may have heard that Uber and Postmates and Lyft sued California to change or to challenge this legislation affecting the gig economy. And so they filed this around the first of the year, and they requested an injunction to stop enforcement of this law, saying that it was causing harm to their business. And I looked that up recently and saw that that injunction was denied, and the court said that there wasn't, they gave a reasoned decision. If anybody wants to look it up, it's Olson versus the state of California in the Western Division, and that has been denied. So we'll see how that plays out, but that was interesting to note there. So for the trucking industry, on December 31st, the judge there made a ruling saying that they're exempt from the AB5 test because their work is preempted by federal law, and that's because there is a law that governs trucking and all of that. So for that industry right now, they're kind of on hold of enforcing this, and from what I've understood, the journalists are perhaps bringing a lawsuit, but for now, I would say we'll have to kind of work with what we have, and Alicia can tell us if there are any Facebook groups out there that people are looking at and kind of making comments and trying to rally behind. So if you are frustrated, Lorena Gonzalez is the assembly member who is the force behind this bill. You can contact her office and let them know what you think. I have called many chambers of commerce and didn't get a lot of traction on this. So even though there's a lot of kind of fodder on social media, that doesn't mean people are exactly taking the real action where it counts. Other resources that we have a free guide that kind of distills all of this down into one page, and we have a whole page on our website dedicated to this topic with videos and documents as well. So you can download that at gradyfirm.com/abc-of-ab5. And then after this call, we'll send out a follow-up email with links to all this information and a recording of today's presentation. And then if you want to learn more about us, you can catch us on LinkedIn, Facebook, Instagram, and then we have a blog and a newsletter that is always disseminating the latest information on employment, business, and immigration law. And then here's our contact information. If you want, you can schedule a free 15-minute consultation to get started. And then we are offering some services that are for the ABCs. We have A, which is the analysis. First step would be to determine whether you should properly be an independent contractor or employee. B is to build out your independent contractor agreement, or C would be to convert employees. So I will turn it back over to Alicia to talk about the tax issues here.
Great. Thank you so much, Jennifer. I'm going to go ahead and open it up to questions. So our first question is, can you please clarify the difference between Berello and ABC tests? Also, I'm just reading directly. Did I hear right when you said that one should do the ABC test and then do the Berello test as the second step? And that's Rawa Negus. Sorry if I'm butchering your name. If you raise your hand and if you want to elaborate, we can have you do that as well.
Okay, sure. So we did chat about this a little bit earlier. So either you're going to look at the ABC test, and if you can show that you beat the 3 pieces, then you're done. So we have, it's not in the regular course of business, we're not being controlled, and we have our own business, then you would just move on. But if you can't meet that, or you meet the other exemptions, then you would look at the prior tests that we gave you specific to that industry, and then you would look at the Berello test. So Interestingly, if you do have an exemption, it's a little bit more work for you because then you have to prove under the Berello test that more factors than not point to you being an independent contractor.
Does that answer your question, Rawa?
Hello, can you hear me?
Yes, we can hear you.
Okay, great. Yeah, thank you for that. So yeah, I was asking because how it sounded to me originally was kind of the ABC was kind of the first run through where you filter out whether it's an independent contractor or employee, and then if you're really needing to confirm, then you go to Berello. But am I hearing that, can you do just Berello or do you have to do ABC?
No. So you're either going to do ABC.
Okay.
Okay, let's just go through this again. So
Yeah.
You're automatically considered an employee unless you can show that you meet these three elements of the ABC test. So A, you're free from control. B, your work is outside the usual course of business. Or C, you have your own established business. So for example, say you're going to hire the Queen Mary to do a wedding, they're going to be fitting under this. They're free from your control. They do work that's outside your business, and they have their own established business. Or if we were to go back to the CPA and lawyer example, they're outside of that, but also they have their own exemption as well. And so then you would look at the Berello test just to confirm that. So this is kind of like the first thing, but most people's analysis does not end here. You would go through all of the exemptions or even that business exemption here. So here we have the exempt occupations and the professional services. And so they can use Berello if they meet these 6 pieces. Then we have the beauty industry. They can use Berello if they meet these 5 elements. And then we have the business service provider contracting relationship. And so they would use Berello if we can show all of these elements that they actually have their own business for themselves. And we're not just using it to pretend as a way to make them an employee. Because I know in the past, a lot of people said, oh, well, just get a DBA and that should cover it. No, that's not true. You have to meet all of these elements on this page and this page, and then we can look at the Berello test. So in some ways it's more uncertain, but it is giving you the potential out in case you want to keep things as independent contractors.
Great. Thank you so much, Jennifer.
Sure.
We'll do one more question before we move on to Ricky, but the question is from Jeff Simon, and it says, what if you hire your neighbor, John Smith, to help with a one-day event, and you only hire him for that one event for the year? Is he an employee for that day? And I know we touched on that a little bit.
Yes, so that was one of the examples that we talked about. So as I said, even if it's only one day, and this comes down to even the I-9 form, which you would fill out, you would say, oh, do I still have to do that? It's only one day. The answer is yes, if they should be classified as an employee. And so that would be this one here that we talked about, just for one day.
Great. Thank you so much. So now I'm going to go ahead and introduce Ricky Johnson with RTJ CPA, and he's going to give us some insight on how this new law has been affecting his clients, and we'll take some questions as well that are specifically accounting related. Ricky, are you there?
Yes, I'm here. Thank you. Good afternoon, everyone. As Alicia told you all, my name is Ricky Johnson, and I work with RTJ CPA. We are a small boutique accounting firm out of Playa Vista. We primarily work with entrepreneurs, small to mid-size operations. We help individuals. Most of our clients are, I presume, like many people who are on the call now, someone with a particular skill set, very good at what they do. They start a business, they start to make money. And then, you know, they all of a sudden have to pay taxes and they need to find someone to help them to understand. So that's really the crux of our business. We take these entrepreneurs who are doing good and we help them to understand and to really understand the tax laws as well as, you know, their business laws as well. So that was a quick little background of what we do. I apologize for not having any slides to put together. As you all know, it's tax season and we're very, very, very busy on this side. However, just to cut to the chase, had I put together a slide, it wouldn't have spoke to any of the compliance aspects of it, right? I think Jennifer did a great job explaining everything here from a compliance perspective. So I'm just going to talk for a couple minutes about the money aspect of AB5, right? Because that's my specialty, right? So when AB5 first hit, most of my clients reached out. They say, hey, Ricky, what's going on with this? What do I have to do? Oh my gosh. Most of them panicked. They didn't know what was going on. So I got that from tons of clients. So the real answer to that is, you know, you always want to stay compliant with any type of tax law or with any type of business law, such as AB5, right? You want to make sure that you properly classify your employees as well as your independent contractors. But what I see, and I'll just kind of, you know, cut to the chase, many clients, the crux of whether or not, like if you're an employer, right, you are asking, you may not want to classify your contractors as employees because you're thinking, oh man, that means I have to pay employment tax, right? And if you're a contractor, you are very likely going to look at it from the opposite angle. You don't want to be classified as an employee because that means come tax time, you aren't going to have the flexibility that an independent contractor would have, namely with respect to deducting business expenses, right? So those are the two sides, and that's most of the time what I'm presented with. So I'll answer both of those, and then that'll essentially be my presentation, right? Because like I say, that's the most of the question. That's what I always get. So if you're an employer and you're asking yourself, should I, you know, should I classify this individual as an independent contractor or as an employee? Jennifer spoke to taking risks, right? She spoke to one example where you have people who will just say, I don't care what the law is, I want to classify, you know, this individual this way or the other. Well, I come from a numbers background, and I'd say if you're an employer and you're on the fence or you're trying to find out how you should classify someone, I think you should classify them, you should try to be as compliant as you can be. Because the difference between an independent contractor and an employee, if we talk about dollars, is 15.3%, right? So if you pay somebody $100 for a gig, if they're an employee, now you pay an extra $15, okay? Then maybe a little bit more for your insurance, right? That has to go up, but not by much. We're talking nominal things here. So if we took a look at the slide that Jennifer had when she was talking about the potential penalties, right? The penalties are there. If we're talking about a risk, the risk must be calculated. You have to say, if I say I'm going to go against the grain, I know these people are employees, but I want to classify them as contractors. You have to look at how much are you going to potentially save in doing that. 15.3% for each individual that you decide to do that for, right? If you do that, you have to then take that number, right? Calculate how many people you're going to do that for, take that number, and then compare that against what the potential loss would be should your non-compliance become an issue with these agencies, right? Should they learn about them? Should they audit you? Do you stand to lose more than what you stand to save? Right? Like if I'm only going to save, let's just keep it simple. If I'm only going to save $15, but I could potentially lose $400 on this contractor, you know, now that you have this information, it would behoove you to make the most informed decision, which is, in my opinion, classify them as an employee, take the $15 hit, and focus on something else in your business That's just the lay of the land. We are in California. We're doing business here. $15 is nominal. If you're in a different type of industry, taxes could be a lot, and then we would want to get around it. So yeah, weigh your cost of compliance versus non-compliance, even if you're on the fence and if you want to be, maybe avant-garde, or if you want to be aggressive about something, always weigh the dollars. Do your best to calculate how much it is if I could take this position, or how much is it if I take this position, because that'll really clarify things for you. So then lastly, I'll talk about if you're on the other end. Now, if you're a contractor and you're looking at whether or not you want to be classified as an employee versus a contractor, I'd say for this one, it's cut and dry. You want to be classified as a contractor, with one caveat, that you have proper insurance, right? Because one of the perks of being classified as an employee is that you get a lot of benefits and overtime, and you get insurance, you get state disability. So if you ever get injured, you have that check that could potentially come in. So if you're an independent contractor, you want to make sure that you have insurance. But why is it better to be an independent contractor versus an employee? It's all about money. Like, how can I deduct, right? If I'm an independent contractor, I can deduct my expenses. I can deduct the cost of doing business. As long as it's reasonable and necessary in the course of my business, I want to be classified as an independent contractor. Because if I'm an employee, I get a W-2 at the end of the year. You give that when you translate that to a tax return, the W-2, you can't deduct anything against that form. It's just whatever the boxes are, that is what it is. You don't, if you bought equipment, you don't have the option to deduct that. So you want to be an independent contractor. Back to the exact same tool that I used for the other example, cost. Like what is it, how much is it going to cost you? Jennifer spoke to the costs of organizing an LLC, setting up a DBA. She also spoke to something that was very important that is often overlooked. If you have a Facebook page, just what a normal business would do. So if you look at the costs, my advice to you all is weigh the cost. It's going to cost you $800 a year to be an LLC in California. It's going to cost you roughly, the hard costs, about $150, $200 to register the LLC, and that's if you do it by yourself without hiring anyone. So that's $1,000 in year one, and then we're talking $800 minimum, every year henceforth, or every year thereafter. So again, $1,000 in the first year, $800 in the next year. That's going to give you a plethora of protections, from your personal assets to your business assets. That's going to make you look more professional. You're going to have your email domain at the end of your name. It has the LLC. And you're doing things proper, and it's going to save you, because that's not a big cost. If you're just doing a one-off gig, you're only going to make $500. Okay, but if this is an actual operation where you're pulling in money, you have to ask yourself, how much is $1,000 worth it? Or is $800 worth it, so that I can be a Schedule C, so that I can properly have my business documents to present to a potential employer or a potential client? Do I have my website? Do I have a proper domain after my email address? Do I look like a proper business to a third party? Is really what that question is. And the cost of doing that is what you must consider and calculate when you make that decision, because the juice is worth the squeeze, because even that is deductible. So that's all I really have to say. I'll pass it back to Alicia.
Great. Thank you so much, Ricky. I wanted to open it up to questions. We have a lot of questions for Jennifer. I wanted to see, does anyone have any, raise your hand if you have any questions for Ricky before we move on to the other questions. Does anyone have any accounting related questions. All right, let's see. We have one question from Rara.
Hi, yes, this is me again. Thanks so much for that. I really appreciate the breakdown, the numbers breakdown. So I see on this slide here, it says that there is a $5,000 to $25,000 penalty fee. And it says per violation. How does that break down? Does that mean like if you have 5 folks that were not classified correctly, would that be 5 violations? How does that calculate?
So I think I'm going to defer that to Jennifer or
Yeah, I
ask
think
her to
that's
keep me
more on
honest.
the-
I think it's per individual.
Per individual, right?
Jennifer, if you can keep me honest on that one. Yeah, if it says per occurrence, then yeah, that's very likely going to be per like individual. So per event, per individual that you classified incorrectly.
Yeah,
Okay.
so if I can jump in, it is per person, and if you do have repeated violations, that's where we get up to this 25,000. It's on a sliding scale, so they are trying to look out for those repeat offenders. And I have a question for Ricky that people have asked me in prior versions of the seminar. So now we're past January and we may be converting to employees midway through the year. So is that going to be a red flag to the IRS? And even if so, you know, we still have to do this anyway. So what do you think about switching mid-year?
I think as far as compliance, like if you are non-compliant and you're becoming compliant, 9 times out of 10, that means that you're classifying an independent contractor, or you're classifying someone you're switching from IC to employee,
Right.
which means that you're raising your hand and paying money. So, excuse me, agencies, you know, these agencies, there's a misconception that they're very advanced with their tech and that they're on top of things, but they're really just like any other business that's doing their best to get, you know, technologically advanced. So I wouldn't say that that's a red flag. I don't, to my knowledge, there's no check that, let's say, the state taxing agency has or the IRS has, where when you file your payroll tax returns and when you file a 1099, that they'll cross-check to try to see that. So as long as you're moving to compliance, I would not say that. I would say that that's not an issue. If you're moving away from compliance, or if you're moving in a direction that, you know, doesn't convene the state, like if you're going from employee and saying, "Hey, I don't need to classify this person as an employee. They're an independent contractor." I love math, so I used to take geometry, and there's something called proofs. When you do proofs, you have to literally write down all of your steps in order to prove that something means something. So if you're going to go against the grain, you should take the proof approach and actually document your reasoning for switching from an employee to an independent contractor before you do it, right? Actually have your proof, actually have your notes with your lawyer, actually have your contracts and everything, put it in a zip file so that it's date and time stamped, and then make the switch, so that if you ever audit it, you have that there, you know, and there's nothing that you can do about it. You can sleep at night.
And let me piggyback off that. So would they ever say, okay, you've brought this on our radar, we're going to look back and realize they were misclassified and we're going to go after you for back taxes? Because on the employment side, under that case dynamics, which came out in the spring of 2018, this law is actually retroactive. So even, and that's going to shock everybody, it doesn't make sense, it doesn't seem fair, but if someone were to bring a lawsuit and say, I've been misclassified, that can go back 3 years under the labor claims. And if you added a business and professions code unfair competition, that could go back 4 years. So you can still, even if you're compliant from today forward, have some retroactivity. So I like to say, number one is kind of stop your liability from this day forward. So like, as I mentioned, when you get off the call today, you have to make a decision how to be compliant. And then you also want to keep this evidence in case you do get an audit. You're going to say, maybe these people, maybe you have 100 employees. For example, maybe 20 of them really were independent contractors. So you would want to have the proof why, or maybe they didn't work as many hours as the auditor is claiming. So that's where you would call a lawyer who's done these audits before, and you would try to reduce the amount that you would owe. So that's just some perspectives there.
Yeah. Yeah.
And so from your perspective, would these agencies kind of figure this out and then say, oh, actually, you should have owed us all this time? Or would that really be, what I have been talking about?
So I think that's a great question, and that is also a concern that some of my clients have posed to me. So the answer to that is, I can't answer with 100% certainty, only with what I've seen. And I used to be an auditor for government agencies back when I first started out. So I do have experience in that field. So I believe that my answer comes with some weight. But at the same time, I do not represent those agencies. So I can't say what they will or won't do with absolute certainty, rather with reasonable certainty. So my reasonable certainty is that I don't think that they'll go after the small fish. I don't think it behooves them to take the average. And when I say small fish, I mean, a business that's grossing 100K or a business that's grossing 200K. I see big fish or medium fish even as businesses that gross 1 mil. So once you hit the $1 million mark, then okay, they may look to reclassify you, or maybe they might look at if you have 50 employees or 50 contractors, if you have a large scale, right? The question is around materiality. So let me rephrase it like this. If you're immaterial, meaning you're small, you don't make a lot of money, or you don't have a lot of employees / contractors, I would not worry about it. If you are large in the sense that you make $1 million or more, you gross $1 million or more, and you have 50 or more employees, then I still wouldn't worry about it, but I would just be more so inclined to make sure that I have a narrative. The best thing that you can have in the face of audit is a narrative to rationalize any decisions that you make, especially the controversial ones like with these. I think that the state will, however, go after the big fish, like these big rideshare businesses. I for sure. I mean, they're already fighting. So that's going to happen because they want a big payday and they want to set the lay of the land, right? If you knock down the biggest, competitor here, or then everyone else will be afraid and they will conform, which is the strategy taken. You have to remember, it costs money to audit. They also do is the juice worth the squeeze to audit. Am I going to audit this person that makes only 50K? I got to pay my auditor X amount, and they're only going to probably get me back less than when I pay my auditor to audit them. So again, just be compliant. Just go to compliance as soon as possible and have your narrative. If there's any gray or if there's any gap in your position, if you think a couple years back or within the statute that I have risk exposure, just document it. That is when you go meet with your attorney and you really realize the value, because your attorney can interview you and ask you, how would I have classified this person properly? And you can ask all those questions and document them there. Once you document them, again, put it in your zip file and then just move on about your business.
And if I may on that, I have had 2 people come to me back November, December. One was a gym, and they had maybe 20 trainers that they had as independent contractors. They got an audit. And then someone who is in the event space and does have a lot of performance artists, he had about 300, and he was getting an audit. So it really can be smaller. And also keep in mind, if anyone is filing for unemployment, that might create a red flag, or somebody left the company and got this great idea to sue you and make some money. That also can put that out there. So I don't want anybody to tune out and say, I'm small, I'm a 1-person business, who cares, this doesn't matter to me.
Right. Thank you.
Oh, thank you so much for this webinar. Yes, I have a question. Let's say if I have an LLC, I'm a musician, and I have a group of it's a string quartet or trio, and I have musicians perform at different events. So let's say if I have an LLC and I hire the person who has an LLC, will it work with business to business relationship?
And so are they in business for themselves?
They're musicians as well, yes.
And so you're asking if they can be part of your troupe, or if, I guess, can you tell me a little bit more about how this works in practice?
Let's say I book the wedding and they booked the string quartet. So I bring all four, like including me, I am a cellist. I bring 3 other people, and for right now they are independent contractors. So I give them 1099s at the end of the year. So then if they have LLC, if they had LLC, would it work for business to business?
Because remember, that isn't the only, that's only one of many factors. So it's really going to come down to control, and are they doing something that's in your regular course of business? So I would argue that a person in a string quartet is, I mean, they might be traveling with you often. They're going to be playing music. You're going to be directing them. That might sound to me more like an employee situation.
I see. Okay. Same with corporations, if S Corp.
So remember, that's only one element. Remember, that was like one element of 6 on the second group. So you have to go ahead and look at that again and make sure that you meet all of the elements before you can, with confidence, say that they're an independent contractor. And then again, before I ever give anybody a conclusive decision, I have them send me a job description, information about the job, so that I can research it and be confident with that final answer, because every single situation has nuances, and you would also want to do it for each job type of people that would be working for you, like different categories of jobs.
Okay, thank you so much.
Okay, thank you.
I have a question here from Emily Bennett, and it says, I'm a event wedding planner that is hired by the consumer, like a couple, not a referral agency. So I'm also not a referral agency, meaning I don't hire businesses under my company. Therefore, I don't fall under the Berello test, correct?
So you could fall under ABC, where they're hiring you as an independent business person. So they don't have control over what you're doing. They're doing something outside what they do. So you would look at the 3 pieces of the ABC test, and you can fit all 3. Then you would end it there. If you can't, then we might try again that business service provider exemption. But you're doing something that's totally outside what these people do. They're hiring you to do the work. The issue is going to be the people who are working for you. Are they independent contractors?
Great. Thank you so much, Jennifer. So I think we're going to go ahead and wrap up. If you have any questions that we did not get to, you can contact Jennifer and Ricky directly. And after this webinar, we'll go ahead and we'll send the recording. And then we will also, I will send contact information for the Grady Law Firm as well as RTJ CPA. I did want to ask you one question, Jennifer. So this is a lot of information, and it can be confusing for some people, or scary, or shocking, overwhelming. Like, what would you say is the good news or the bright side of this new law?
I think the bright side is now you have the information, and you know at least how to issue spot and figure out what are the things from a compliance, legal, and tax side that you need to look out for. Then you need to hire a service provider that you're comfortable with, that does indicate an expertise in the area, and then just make your decision and go with it and document it, and then move on. So we don't want to have you living in fear of being audited and spending tens of thousands of dollars to get out of a lawsuit. If you're not sure and you're on the fence, make them an employee. And the benefit, a lot of times people say, okay, but they don't want to be an employee. But the benefit to them is they are getting workers' comp. So if they're injured on the job, there is a way under California to get people the treatment that they need. They're paying into Social Security. They'd be getting the paid sick leave. So there is that element of protection. They're now, which wouldn't be great for the employer, but available for any wage claims or labor claims. So I guess the bright side is there's going to be some more protection for workers, and then you just need to do that risk assessment and say, I just want to be on the safe side. I want to do it right. And it's just better for everyone, for you as an owner, to just do things correct, have the right record keeping. And then one of the services we offer, again, we have ABC services. Number one is analysis. And so that's where you can contact us and hire us, and we can look through the job and give you our opinion on what we think you should do moving forward, and then either write your contract or give you the onboarding documents. And then that segment also includes a 1-hour call with me where I explain how to use the documents and answer any individual questions one-on-one.
Great. Thank you so much, Jennifer.
Thank you. It's a pleasure.
So yeah, I want to thank everyone for joining today's webinar, and I want to give a special thank you to Jennifer Grady, who put a lot of work into this. I pitched the idea to her in February, and she was excited for the opportunity to be of service. And again, please send your questions to Jennifer and Ricky. Thank you, Ricky Johnson, for joining as well. We appreciate you joining and sharing your expertise. We're going to send out an email with additional tools, as I mentioned before, and resources after this webinar. And by tomorrow, we'll send out a recording of the webinar, which you can hold on to for reference. But also, please, please, please share with your fellow event colleagues. I'm sure they have lots of questions as well. And then lastly, Deshawn Wynn from Winning Touch Events, she'll be forming a group for those that want to lobby for our industry. She wasn't able to make this call today because she's on site and at an event as we speak. So I'll send additional details as well for those who are interested in being involved in that effort. And if you're aware of any existing groups that are doing that as well, please email me and let me know so we're not dividing efforts and we can come together on this. So have a wonderful afternoon, and thank you everyone for joining.
Thank you. Bye-bye.